Well, hello, everyone. This is the D.C. Office of the Tenant Advocate's new webinar series, OTA from A to Z. I'm your host, Derek McGinty, and today we're going to be talking about your lease. If you rent your apartment or home in D.C., it's probably the most important document you've signed, and I'm willing to bet you didn't even read it, or at least not very thoroughly. Well, today we're going to make that lease work for you. We're going to answer your questions about it, maybe the terms, maybe late fees, and of course, what happens when you want out. Our guest is an attorney. His name is Stephen Dudek. He is also Outreach and Education Coordinator for the Office of the Tenant Advocate. Stephen, so good to have you here with us.
Thank you for having me.
You know, I have signed a few leases, I should say, from my days as a tenant here in Washington, and I, too, didn't really read it. Not the best idea.
No, you should always read the lease. Read it over. If you have questions, you can come down to the Office of Tenant Advocate, and we can answer those questions and explain the lease terms to you.
Give me an idea of what you're not seeing if you don't read your lease.
You want to know if you have to pay late fees, when those late fees kick in, if you can sublease, whether you should sublease, also when you need to give the appropriate notices, especially if you decide to end your tenancy, when you need to give that notice to the landlord.
Okay, so these are important things, and when you need to know them, it's basically too late to just find out about them, is what you're saying.
Yes. You should always read the lease because the lease is your governing contract.
Now, I'm told that lease issues are the top issue that faces tenants when they come to OTA. What are some of the things that you ought to look for in that lease?
So a couple of things that you want to look for is definitely the fees and definitely your responsibilities. A lot of the questions that come up is who's responsible for what, and the lease governs that. The lease will tell you if you're responsible for water, if you're responsible for gas, or if the landlord is covering all the utilities. Also, in regards to late fees, it talks about the percentage when that late fee will be charged, because we'll get into that further, but there's a 5-day grace period before a late fee is charged onto a tenant. And again, the notices, those are the biggest things, because if you don't abide by the timeline that's set in your lease, it can have severe consequences where you may be penalized to pay an extra month's rent, and no one wants to do that.
Nobody wants to do that. Now, if you're reading through that lease, are there things that the law mandates should be in there, and that if they are not there, it's a red flag?
Yes, and also the law mandates that there's things that shouldn't be there, unenforceable clauses. For example, there's no tenancy at will for residential tenancies.
What do you mean by that?
So the landlord can't just come and say, I want to end the tenancy. The only way they can do that is they must abide by the eviction statute. And so if you see a clause that says either the landlord or the tenant can terminate the lease, that is an unenforceable clause, because only the tenant in the district has the ability to terminate the tenancy.
Interesting. Any other strange things that you've seen in leases that we ought to know about?
There's a lot of strange things because it's a unique document with any landlord-tenant.
Sure.
And yes, we have the common standard type, but different landlords have different lease addendums. They talk about whether pets should be allowed or not allowed. And with it, a lease is your contract. And so you can negotiate the terms of the contract. And that's some things tenants should be aware of, that before you sign it, read over it. If you don't like something, you have the opportunity to negotiate with your landlord to either get clarity or to say, maybe this isn't the best situation and I don't want to sign
So in
the
other words, don't take it as though you have to sign that lease as is. Read it. Maybe you might want to make some changes.
Exactly.
Okay. Now, what is the basic length of a lease, and how long or how short can it be?
It all depends. I've seen leases that is 1 page, and I've seen leases that are 70 pages long.
Okay. No, when I meant length, that's funny. No, I was talking about the amount of time.
The amount of time.
In terms of, this is a 1-year lease, a 2-year, 1 month, month to month. What are the sort of some of the variables there?
So the common lease is a 1-year lease. However, with DC being a transit city and we have a lot of individuals who come out of the country, they typically sign maybe a 3 to 5 year lease, which you want to make sure you read over that before you make that commitment. And then also we have month-to-month tenancies, and that happens either after your lease expires, you automatically convert to a month-to-month tenancy, and so you can't be evicted just because your lease expires. Or you can also sign a lease that states that you're a month-to-month tenant.
Let me just clarify something very quickly. if you're on a one-year lease and that lease runs out, that doesn't mean the landlord can say, that's it, I want a new tenant?
Exactly. Your lease in DC automatically converts to a month-to-month tenancy. So if you pay your rent and you abide by the terms of the lease, you can live in your unit for the rest of your life.
Wow. Now, when you're talking about the transient nature of DC, one of the things that comes up is subleasing. Sometimes you can, sometimes you can't. How does that work?
Subleasing is very complex, and I would recommend tenants to talk to an attorney before they want to do subleasing. The first thing that they need to do is notify their landlord that they want to sublease. And this is all governed in the lease, and usually there's a clause that states that you must get the landlord's written permission before you sublease. And so always do that, because if you don't do that, you're violating the terms of the lease and you could ultimately be evicted.
Do some leases say no subleasing allowed?
Yes.
Is that okay to say?
And that's permissible. The landlord has the right to say that he's accepting no subleasing and no assignees,
Okay.
but it has to be clearly stated in the lease.
Now, there is a DC Tenants Bill of Rights. Now, how does that affect leases? What does it say that landlords and tenants have to do for each other, in essence?
So that's one of the benchmark things that the OTA has done. Back in 2013, we made it a responsibility of the landlord to put that in the lease as an addendum, so all the tenants are aware of their tenant rights. So each tenant who signs a lease here in the district should be receiving a copy of the Tenant Bill of Rights after they sign the lease.
What are some of those things? Can you recall any of them?
Yep, so the Tenant Bill of Rights goes through your rights from all the way signing the lease to security deposits, evictions, and a general overview of your rights as a tenant in DC.
Okay. Now, late fees, you mentioned that earlier. Those can sneak up on you if you miss a rent payment or don't get it in on time. Are there limits to what a landlord can charge you in a late fee?
Yes, so with late fees, there's 4 things that you need to know. The number one thing that you need to know, and this law changed a year and a half ago, is that you cannot be evicted for non-payment of late fees.
Really?
Yes, so you can only be evicted for non-payment of rent, which is a great transition to what it used to be. The second thing is there's a grace period. So a late fee cannot be charged until 5 days after your rent is due. So it's still important to pay your rent on time, but you at least have that safeguard knowing that if you pay on the 2nd instead of the 1st, that you're not going to be charged. And then the last thing is your rent is capped, or your late fee is capped at 5% of what you rent and can only be charged once a month.
That's interesting. A point of full disclosure, my dad was a landlord in D.C., God rest him, for years. And at one point, he actually stopped charging late fees because a court ruled that if he was accepting late fees, and that meant it was okay to be late on your rent as long as you paid the late fee. So he didn't want people to be late, so he said, okay, I won't charge late fees, but if you pay after the 5th, you can get evicted. Was that legal? Would that be legal under the current system of doing things?
Yes, so the landlord does not have to charge a late fee. If he charges a late fee, it has to be stated in the lease, and it will clearly state that you can only charge up 5%. Now, if your dad as a landlord was saying, hey, I'm charging a late fee, but I'm charging it 3 times a month, that would be an illegal late fee
But
charge.
if he's not charging a late fee, does that mean that if you don't pay on time, does he have more leeway to evict?
If you don't pay your rent on time, they have a right to evict you. Okay, and that's separate from the late fee. So even though there's that grace period, we still want tenants to pay on time because we don't want them to jeopardize their tenancy.
All right, we're going to do something a little different here. We're going to look at some questions that have been sent to us from tenants here in Washington, D.C., to the OTA. Here's one. It says, there's a clause in my lease saying that either the landlord or tenant can end the tenancy. Can this be enforced? And we talked a little bit about that.
We did talk about this, and this is one of those unenforceable clauses because, again, the landlord can only abide by the eviction statute to get a tenant out. The tenant can, when he chooses, can end the tenancy. Now, if they're still in the lease term, it's a little bit difficult, and we can talk about that a little bit more.
Yes, we will talk about that.
But if it's a month-to-month tenancy, all they have to do is issue a 30-day notice to vacate to the landlord.
Next question. My lease is expiring in 90 days, and I received an email from my landlord saying he he wants me to move out at the end of the lease. Do I have to move?
No, and this is something that is a great protection of tenant rights in DC, is that a landlord cannot evict you because your lease is expiring. And this goes back to the eviction statute,
Sure.
and I'm referring to this eviction statute all the time, but it's not an evictionable offense, and that's why your lease automatically converts to a month-to-month tenancy, and you can live there indefinitely.
Oh, next question is, I'm a month-to-month tenant, but my landlord said I have to give a 60-day notice because there's a clause saying that in my lease. Do I have to give a 60-day notice to move?
No, you only have to give a 30-day notice to vacate.
Regardless of what it says in the lease.
Regardless of what you say, because this law actually changed a year ago, because we saw this all the time, is month-to-month tenants would have to give a 60-day notice even though they were month-to-month, and DC Council's like, that doesn't add up.
Doesn't seem fair.
Yeah, so when you transition from a fixed-term lease to a month-to-month tenant, that changes, and the law precedes the clause in your lease, so you only have to give a 30-day notice.
Final question is, my lease is expiring at the end of the month. Now, my landlord wants me to sign a new lease. Do I have to?
You do not have to. You have a right to continue as a month-to-month. However, the landlord can be quite savvy, and what he may do is he may increase your rent at a higher amount if you continue as a month-to-month versus giving you a lower rent increase if he to entice you to sign that
And
lease.
I guess if you sign up for a whole year, then the rent is what it says in the lease.
Your rent stays the same, and everything that is in that contract stays the same, because the landlord cannot unilaterally change the terms of the contract.
DC often ranks near the top of cities where people have to move in and out quickly. You know, administrations change, people have to go. What are the top things to know if you want to end your lease?
So if you want to end your lease, it all depends where you are, right? So if you are still in the living out the terms of your lease, say 6 months into it, you got the call that you need to move, the first thing you need to do is review your lease. And this is why it's essential to read, because if you read your lease, you already know which section you want to go to. So you review your lease and you see if there's a clause there. If there's a clause that states this is how you break your lease, that's what you have to abide by. If not, then it's open up to your negotiation tactics to be able to end that lease.
But if you end the lease before the end of the term of the lease, are you likely to be on the hook for those months of rent that you're not paying because you're out of there?
Yes and no. It all depends, right? And that's the legal answer that we'll usually give to a lot of tenants and then explain why. And so the reason why it depends is it depends on the situation and why you're leaving. If you're leaving due to military or to an involuntary job transfer, some landlords do have clauses in that lease saying you have the ability to break the lease without penalty because of those actions. If you don't have those clauses and it's silent, you can still negotiate. You may say, listen, I have 6 months left. I'd be willing to give you a month or 2 months rent in return that we adjust or amend the lease to say that the end date is this, so I'm not responsible for the remaining 4 months.
Sure.
In addition, there's also the duty to mitigate damages. And so what that means is the landlord, if a tenant abandons or leaves without getting any agreement in place, would be on the hook to make sure that they protect themselves. Now, they can still go after the tenant to try to get that money, but they have to show that in a good faith effort, they try to find a new tenant to come in, they advertise, they were harmed because the tenant left, they couldn't find a replacement, but the landlord actually has a duty now to mitigate their damages.
So if the landlord does find a new tenant, then he cannot ask for you to pay those intervening months of rent.
Exactly. Unless it all depends. It's a case-by-case situation. So if you're in that situation, definitely call the OTA so we can best advise you.
As you've worked with the OTA on things like this, how has the atmosphere of the city changed as the economy has boomed? We've seen so much new construction, so many people coming back into D.C. where at one point people were moving out.
Yeah, and I think that that's great, and it all comes to that people want to live here, and they're signing the leases to live there, especially for a year, 2 years. And I think that speaks to just the development of the city and just what the city has to offer.
But with so many more well-to-do residents moving in, are people are still not reading what they're doing? Or what's the situation there?
I think no matter what class or financial background that you have, that people don't tend to read their leases because it's a lengthy document, because you're thinking that the standard lease is 25 pages, then you have additional addendums, then you have all the things that are required to give, like the Tenant Bill of Rights, housing code, statutes. It can be a daunting task to read it. And so that's why if you have questions, or even before you want to sign it, comes to the OTA, meet with an attorney or case manager, and we can review that lease page by page so you have an understanding what you're signing.
If you don't have time to do that, are there certain pages or certain topics that you need to look at, and so you can kind of say, if I know this is okay, I'm probably all right?
Yep, so definitely the first page is always the first thing that you want to read, because that will give you the terms, how much your rent is, when rent is due. The other clauses that I would focus on is the subleasing clause, whether you can or cannot. The late fee clause, which is usually around 9 and 10, is usually where it's ranked. And then the tenant's responsibility. They'll talk about what your responsibility in regards to maintenance of the building, and you definitely want to be familiar with that just in case if anything is under your purview.
You know, in your role, have you seen a lot of cases where landlords have tried to abuse tenants by, putting things in the lease that, as you say, are not enforceable?
Yes, all the time. And I'm happy that the OTA is there to be that safeguard for the public. And one of those things would be that we're seeing a trend now is that landlords are actually charging a deductible to get services to be done. So say, for example, and we've seen this more with the public housing, the Housing Choice Voucher recipients, where they have to pay a $200 deductible every time the landlord sends a service member out to do some type of construction. And that, in a sense, is a public policy issue because, one, if you're on a voucher, you're financially burdened, but also it breeds slumlords because why is that tenant going to waste an additional $200 to get someone to fix?
So wait a minute, let me understand this. You're saying that something in your apartment's broken, and you say, come and fix it, which landlords usually think are supposed to do. They say, well, come, but it's going to cost you $200.
Yep. Yeah, we've seen that, and we've seen the trend of that, and it's a very scary trend because it's a violation. It's an unenforceable clause, and not to go into the legalese of everything, but ultimately the landlord has a responsibility to provide a safe, clean, and habitable unit for tenants, both in their individual unit and the common spaces, and therefore we feel that it negates that responsibility if they're saying, before you do that, you must pay some type of money.
Right. Now, you say you feel it negates that responsibility. Does the law say it negates that responsibility, or is this one of those murky areas where...
The law says the issue of it is, one, is trying to get tenants to be able to be reimbursed for the money that they spent. So that is sort of where the murkiness comes into that. It would be up
in other words, if you've already paid, you might have some trouble getting that money back.
Yep. But come to the OTA, we can talk about how filing a complaint in small claims court to get that money back.
It sounds to me the big problem you might have is that people just don't know what their rights are.
Exactly. And that's why, as the coordinator of outreach and education, we offer Renters' Rights 101 on a monthly basis, which goes through your rights from the application process all the way to evictions, all the way to move out. And it's a 2-hour presentation, and it gives you that foundation on what your rights are and also to what to look into your lease.
All right, Steve Dudek, thank you so much for joining us. We appreciate it. That's a good note, I think, for us to finish this up. I'd like to, again, we thank Steve for participating in making your lease work for you. We hope you enjoyed it. We hope you learned something. I know I did. Well, this webinar and the others in our OTA series will be available on the OTA website. That's ota.dc.gov. Or you can contact the OTA via the telephone. The number is 202-719-6560. Or just come by for a visit, 2000 14th Street Northwest. Hours are 9 to 4, Monday through Thursday, except holidays. We'll see you next time.